Believe we're live. Chair Kelly, if you'd like to call the meeting to order, we can start.
All right, thank you. So let's bring the meeting to order. We have as first of all, let's take the roll. Mr. Roca, can you help me with that?
Absolutely. Member Caffrey?
Here.
Member Cuniff?
Here.
Member Martinez?
Here.
Member Marks?
Here.
Member Selvin? Chairman Kelly?
Here. So we have a quorum. Is that right, Mr. Roca?
Yes, sir. We have a quorum.
I move that we leave the, well, let's approve the agenda, since that's a logical thing to do. Can we have a motion to approve the agenda?
I'll move that we approve the agenda.
Any objections? Hearing none, the agenda is approved. Review and approval of the minutes from our June 9 meeting.
Chairman, I apologize for interjecting, but we have, because we're on Zoom, the AG's IPRA guidance requires that we do roll call votes on all motions.
On each motion?
Correct.
Yes.
Is that right? Okay. They won't let me do the minutes and the agenda on the same motion?
That too.
Okay. So on the motion to approve the agenda.
I can second that.
Thank you, Mr. Martinez. And would you call the roll, Mr. Roca?
Member Caffrey?
Yes.
Member Cuniff?
Yes.
Member Martinez?
Yes.
Member Marks?
Yes.
Chairman Kelly?
Yes. And the next item on the agenda is approval of the minutes from our June 9 meeting. Is there a motion to approve?
I move to approve the meeting minutes from the last meeting.
In a second, please.
I will second.
Mr. Rocco, we have a motion and a second. Would you call the agenda, please, or call the roll, please?
Member Caffrey?
Yes.
Member Cuniff?
Yes.
Member Martinez?
Yes.
Member Marks?
Yes.
Chairman Kelly?
Yes.
Motion passes.
Thank you, Mr. Roca. The next item on our agenda it reads ethics training by Jeremy Ferris, Executive Director of the State Ethics Commission. And Mr. Ferris, I want, on behalf of the board, thank you very much for coming today. My fairly amateur and new observation, since I'm new to the board, is that the work of this board can very quickly get down into the weeds. And I thought it would be helpful if on a higher level, we had the benefit of your expertise as I think you are, I'm not sure if you're a member or professional staff to the State Ethics Commission, but I know you know the subject very well. And I wondered if you could just briefly introduce yourself, and then we would very much enjoy hearing your presentation.
Sure. Thank you, Chair Kelly. I'm Jeremy. I'm the director of the State Ethics Commission. Years ago, now Judge Arias, then David, you and I represented some parties before the Board of Ethics, so it's a pleasure to be back. And I've had the pleasure of meeting and working with Mr. Roca during his time at the Roundhouse. I'm happy to talk. I mean, the agenda has me down for an ethics training, but what I was hoping to do is say a few words about what I think ethics agencies, both at the state level and the large municipal level around the country, are doing. The kind of normative principles that animate our work, and kind of describe my view of that from the view from the Sandia Crest. And then I can tell you a little bit about the state analog to your agency, the State Ethics Commission, and what we do and how we do it. So that would be my plan, if that's all right with y'all.
Yes, Mr. Paris, that's brilliant. That's what we would like. And again, we're thrilled to have you with us. You lead as you wish at this point, please.
All right. So I was hoping that we could just talk instead of me presenting a slide presentation to you off of PowerPoint. So let's just do that. Let's just talk together. So I think that ethics agencies at the state and local government level are really animated by two main normative principles. I think there's two kind of deep ethical concepts that organize ethics law, either at the constitutional level or the statutory level or the ordinance level. And the first is it's this public trust principle. It's the idea that's foundational to the Republican form of government, that the powers that we have access to as government employees, as government officials, the prerogatives of our office, the discretion that we use, the property that we have access to, the government property that we have access to, the public funds that we make decisions about expending, none of that is ours. We don't own it. We can't use it however we might like. It's powers and prerogatives and property that government officials and government employees exercise in trust. It's a kind of trust relationship with the public at large. And so that those powers, those prerogatives, those resources, that property can only be used for the public's benefit and not for the private benefit of the people who happen to occupy government office or the employees of government. And that's a very, very ancient and foundational normative principle behind our government. And at the state level, it's also in statute. It's in Section 3A of the Governmental Conduct Act, that normative principle is codified into statute. But it also kind of organizes and animates a whole body of state law. So there are several ethics provisions, government ethics provisions in the New Mexico Constitution, the interest in contracts clause, the emoluments clause, the anti-donation clause. Those are all constitutional ethics law that in different instantiations are just applications of this core normative idea, the public trust principle. The same goes for the bodies of ethics statutory law that we have in New Mexico, the Governmental Conduct Act, the Gift Act, in many ways, the Procurement Code are statutes that apply this basic idea in different settings. So that's the first, the kind of from the 30,000 foot kind of view, the airplane view. That's when we're looking at the landscape of what our agencies are doing. We're enforcing laws that are animated by that basic principle, the public trust principle. The second normative concept that I think undergirds a lot of what we do, it relates to the importance of disclosure. And so I think there are two reasons why disclosure and regimes of disclosure are vital. The first is that regimes of disclosure, and by that I mean laws that require people in government to disclose certain facts that they otherwise might not want to disclose, such as their financial interests, such as who gave their campaigns funding, disclosures around lobbying activities, disclosures that relate to second employment, to interests in state contracts. We have a lot of regimes of disclosure in ethics law and in campaign finance law and in kind of legislative law. And these regimes of disclosure, they're really important for two reasons. The first is they're in the service of that public trust principle. If we have good and effective regimes of disclosure, then the public and the oversight agencies and our ethics agencies, we can check and enforce that the public trust principle and all the laws that are informed by the public trust principle are being complied with. The disclosure regimes and all of the disclosure forms that people in government complete enable us to, in the public, to check that government employees aren't burdened by conflicts of interest, that they're making decisions actually in the benefit of the public, with the public in mind. That's one thing that disclosure regimes are doing. The second thing they're doing is an effective disclosure regime makes it much less likely that folks who occupy government roles, who occupy positions of power, are not going to abuse their power to enrich themselves or their friends. Disclosure provides a very large deterrence role with respect to the public trust laws. And then I think there's something else completely separate that disclosure regimes and disclosure statutes are doing. And this separate idea, I think, is equally important to why our agencies, our kinds of agencies, should enforce them. And this relates to how we justify the kind of democracy that we actually have versus the ideal theory of democracy that we're kind of brought up with since junior high school. The ideal theory of democracy is that our districts, our representative elected bodies, be it the Congress or the state legislature or a city council or a county commission, a water district, whatever, what have you, are districted bodies. They represent, the members elected to those bodies represent and are the voice for the constituents in their districts. And in the United States, we take districting extremely seriously. It's why we do a census every 10 years, so that we can get the apportionment right, that we can get the population count right, so that districts can have an equal number of people, so that under the Equal Protection Clause, people's vote has an equal count. Equal in congressional districts, roughly equal in state and local districts. So we take districting really seriously because of this ideal theory that the elected representatives are the voice of the people that live in their districts. Okay, that's the ideal theory, but there are many departures from the ideal theory, starting with the basic fact that our elected representatives, their views are not only tutored and not only informed by people who live in their districts. Their views on policy, the way they set their agenda, the votes they take, are tutored by all kinds of other people and interests that don't live in their districts. Regulated entities, lobbyists, campaign supporters, the party head, the party leadership, people in DC, think tanks, people they went to law school with, people they went to college with. All these people may or may not live in their district. And so we kind of hit the question of, well, how do we justify normatively this kind of democratic system we have, where our elected representatives, their views are tutored and informed by so many other interests other than the people that live in the district? And I think one way that we do that is with regimes of disclosure, so that, my elected representatives, they don't come around the house every so often. Maybe they come around the neighborhood and knock on my door, before an election. But apart from that, I don't hear from them so often. But if I can check and I can look and see who's giving to their campaigns, who's been lobbying them, that helps me with my decision as to how to cast my vote in the next election. And so disclosure, it kind of comes in and fills the breach, the kind of normative departure from the ideal theory. And I think this is why campaign finance disclosure regimes, lobbyist disclosure regimes are central. I think they help to justify the democracy that we actually have now. And I know that's a big part of what it is that the Albuquerque Board of Ethics does, and it's also a big part of what the State Ethics Commission does. And so in the state, Yeah, there are several disclosure regimes. The most important of which are the Campaign Reporting Act, the Lobbyist Regulation Act, and the Financial Disclosure Act. And so that's just kind of my pitch. That's what I think we're doing at a very general level in ethics agencies around the country, at the state level, at the congressional level, at the large municipal level, like yourselves. And I guess I'll talk a little bit about the Ethics Commission's jurisdiction and powers, and kind of what it is that we do, so that we might have a fruitful discussion and comparing notes there.
Thank you.
So the State Ethics Commission, it's a constitutional agency. It's created by Article 5, Section 17 of the Constitution. It's here to stay. There are 7 commissioners. There are 3 Democrat and 3 Republican, and 1 declined to state commissioner. Our agency only works if there is a bipartisan consensus. So it takes, the State Ethics Commission is necessarily bipartisan. It takes 2 Democrats and 2 Republicans to constitute a quorum. And it also takes 2 Democrats and 2 Republicans to authorize any action. And so the Ethics Commission operates differently than the normal common law rule of government agencies, where a majority is the quorum and a majority of the quorum is sufficient to authorize action. For us, we have to have 2 Democrats and 2 Republicans for everything we do. Thinking about the Ethics Commission kind of from a separation of powers perspective, we have a quasi-judicial role, we have an executive role, and we have a small delegated legislative power. And I'll go through those 3 quickly. The first and main thing the Ethics Commission does is it investigates, it receives, investigates, and adjudicates administrative complaints alleging violations of the ethics law that the commission has jurisdiction for. So that's the main statutes are the Governmental Conduct Act, that's our state's conflicts of interest law, the Procurement Code, the Campaign Reporting Act, the Financial Disclosure Act, the Anti-Donation Clause. Those are the big laws that the commission has subject matter jurisdiction for in its quasi-judicial setting. In its quasi-judicial setting, the Ethics Commission has personal jurisdiction over a large number of people. These are the people that can be lawfully hauled into the State Ethics Commission and made to respond to a complaint and be subject to remedies that the commission could impose. For us, that's every official and employee of the legislative and executive branch of state government. It's all of the people and entities in New Mexico that are subject to the Campaign Reporting Act. So all the candidates, the incumbents, all the PACs, all the independent expenditure filers, all of the lobbyists and lobbyist employers, and every entity that's subject to the Procurement Code, which is all the contractors to the state and any entity that responds to a state agency, RFP or ITB, request for proposal or invitation to bid. That's the State Ethics Commission's personal jurisdiction. What is important about the State Ethics Commission in this setting is, and what's landscape shifting, is that these statutes, these laws, the Anti-Donation Clause, the Governmental Conduct Act, the Campaign Reporting Act, before the State Ethics Commission, those statutes didn't come with a private right of action. And so unlike IPRA or unlike OMA, which comes with its own private right of action, and it kind of has the private attorney general model where the plaintiff's bar enforces those statutes against the government, before the State Ethics Commission, really only the Attorney General's office or the district attorney's office could enforce violations of our state's public interest laws and disclosure laws. What's landscape shifting about the State Ethics Commission, the constitutional amendment and the statute, is now anybody can file an administrative complaint and have that administrative complaint adjudicated in the State Ethics Commission, and then that case can make its way into the state courts. So that's the first thing we do. In connection with that kind of adjudicatory quasi-judicial role, for which we have, in the weeds, rules of procedure, hearing officers, the commission serving as an appellate body, much like much like the Albuquerque Board of Ethics. In addition to that process, we also issue advisory opinions. And those advisory opinions are published on one source, and they become the binding precedent for the commission in its quasi-judicial power. So that's the first that's the judicial power tranche of what we do. The executive power tranche of what we do is we kind of act as a kind of a junior varsity attorney general's office with respect to the public trust and disclosure laws. So the same set of laws that the commission has subject matter jurisdiction for, the commission can bring civil actions to enforce in state court. So whereas the former was kind of complainant versus respondent in the State Ethics Commission, that's the posture of the administrative cases. I'm talking about State Ethics Commission versus defendant in the Second Judicial District Court or the First Judicial District Court. That's a power that the commission has. And from time to time, the commission authorizes civil actions against defendants. And if we can't settle those before filing, we file civil actions to enforce our state's ethics and disclosure laws. That's our main executive function. And then the commission, the State Ethics Commission, has a very limited delegated legislative power. So the State Ethics Commission does not have the delegated legislative power to create a code of ethics for the state employees and to go off and enforce that. We do not have that power. Really, the only delegated legislative power that the commission has is the power to promulgate its own rules of procedure for its administrative cases. And so from a powers perspective, kind of walking through the main things of what the commission does, that's about it. The Constitution enables the legislature to add tasks to the State Ethics Commission. We kind of have a large other duties as assigned function or possibility. And that's happened since the creation of the Ethics Commission. So the commission had a role with the Citizen Redistricting Committee and has a role in the kind of the state agency that creates advisory maps for the legislature. Since the commission's creation, the legislature has also tasked the Ethics Commission with reviewing and adjudicating administrative complaints against notaries public. And so there's different other kinds of things that the attorneys here in the office do that is somewhat of a departure from the main public trust and disclosure laws. But that's basically what it is that we do. It's an extremely legal agency. We have an attorney staff, and they spend their time working on litigated cases or working on administrative cases or drafting advisory opinions.
That's awesome, Mr. Ferris. Thank you very much. Can you put a pin in whether it's our state or federal government when this evolution of ethics, rules and regulations, statutory, constitutional provisions began?
Sure. Most of this stuff began after Watergate. Most of the ethics agencies in the states around the country came to life in the years in the wake of Watergate. It took New Mexico about 40 years, from what I understand, to come around to creating a state ethics commission. I guess the thing that I can say about that, Chair Kelly, is that there's a lot that we got right by virtue of being a late mover. New Mexico is often a late mover, but with respect to the creation of a state ethics agency, there's a great deal that was learned from the experience in other states. And the drafting attorneys at Council Service that worked on the constitutional amendment, on the State Ethics Commission Act, the legislators that worked on those statutes, they got a lot right. Starting with creating the State Ethics Commission as a constitutional entity, as opposed to a statutory entity that's, at the discretion of the legislature, or worse, an entity that's created by executive order that's at the discretion of the governor. Making a constitutional entity makes the Ethics Commission more likely to be independent. The The appointment process is very well thought out with our State Ethics Commission. The removal process is also very well thought out. So state ethics commissioners, my bosses, the 7 commissioners, they can only be removed once appointed by the Supreme Court, and only for cause. And so that also makes, kind of protects their decision making, and New Mexico very much got that right as well. And I guess the last thing that we got right in the early days of the commission is, instead of the commission's funding flowing through another agency, the State Ethics Commission has its own line item in HB2 in the Annual General Appropriations Act. So we're separately funded, and so the funding for the commission can't be cut off through, because its funding is routed through a cabinet agency that the governor controls. And so there's just a lot that New Mexico came late with respect to a state ethics commission, but I think by virtue of coming late, got a lot of things right.
Oh my goodness, I think it's brilliant that the beginning of this was Watergate, and as you say it now, it stands to reason. And I guess it's probably the case all over the country in one way or another that breach motivated the states to do better.
Yeah, that's my understanding. I mean, Watergate was before my time, but my understanding was that it was such a shock to the system, and that there were many good government nonprofit organizations that formed in the wake of Watergate and in response to Watergate. Organizations like Common Cause that ended up, having a national presence, and so that's my understanding of it, is that all of this began with Watergate. But that's not to say that the United States didn't have an ethics law before Watergate. We certainly did. This is an area that I'm quite interested in. Before ethics statutory regimes, before municipalities codified ethics ordinances, before states did so, and conflicts of interest statutes, we still had an ethics law, but it was in the common law. It was enforced through breach of fiduciary duty actions. And so you can go back and read 19th century United States Supreme Court cases that pre-existed Erie Railroad, pre-Erie cases, where we kind of had a uniform federal common law, and see the application of breach of fiduciary duty, private actions against government officers, and that I think is the beginning of ethics law in our system. And then the statutory ethics law kind of comes after that and is very much informed by the different ways that the breach of fiduciary duty actions against public officials, government officers, the different ways those cases created that body of common law.
That's terrific. Mr. Ferris, would you have maybe 5 to 10 more minutes to take a few questions if there are any?
Yeah, absolutely.
Ladies, gentlemen, does anybody have a question for Jeremy? If not,
I could ask a question. If not, I know that the Albuquerque Board of Ethics, that your cases are mainly related to Albuquerque's campaign finance ordinances, but I'm curious what other kinds of cases that you all see and review.
probably, who would like to take that? Jason? I'm fairly new to the board, 3 months.
Let's delegate that one to Ethan if he's still on.
No, I think Ethan had a meeting to go to.
Okay. We're called the Ethics Board, but or Board of Ethics, but really we're a Board of Elections. And in I think the current commission's experience, we've been concerned with the public finance law, but other campaign practices, I think some of them would be within our purview. petitions. I'd have to check, but we're
Right.
really focused on elections, and we do not, right? We do not have the same purview as the State Ethics Commission.
Yeah, the full name of the board is the Board of Ethics and Campaign Practices. So
Yeah.
just usually gets shortened to Board of Ethics.
Yeah.
The State Ethics Commission also has jurisdiction for the state's public campaign finance system, but which is much more limited in scope as compared to Albuquerque. So the state of New Mexico has a public campaign finance system, but it's only for judges. It used to be for judges and PRC commissioners when they were elected, but that recently changed. And so in state law, it's called the Voter Action Act. And it's an interesting name for the state's public campaign finance statute, but New Mexico has one. It's really just limited to judges. And I guess that might be the only instance in which the commission might have subject matter jurisdiction against a judge, is with respect to their conduct under that public campaign finance statute.
Well, thank you very much, Jeremy. It's a real pleasure to meet you, and you've been in that position a few years?
I have. The constitutional amendment was enacted by the voters in November of 18, and the commission came to life on July 1st of 19, and they hired me as the director not long after that. And so I've been in the position 4 years. My position is term limited. The ethics, or the State Ethics Commission's executive director, has a 6-year term, renewable for 1 term, and that kind of makes sense. I think there are other term limits around the State Ethics Commission, but I think the term limits make sense so that there can kind of be, just turnover and new faces in this agency. It shouldn't just be the creation of a single individual, which it might otherwise be if it didn't have those term limits. So I've been here 4 years and very much hope to complete my first term.
Thank you very much.
Yeah.
Anybody else before we?
Yes, Mr. Chair.
Mr. Martinez.
Sure. Yeah, Mr. Ferris, is it a requirement for municipalities to have an ethics committee, or is it suggested? And how do you deal with, smaller communities? Is it just a reporting basis of whoever might think there's a violation?
I appreciate you asking that. So there is no legal requirement for local governments, county or municipal governments, to have ethics agencies. There is a requirement for such agencies to have a kind of code of ethics, which can be more stringent than the Governmental Conduct Act. But really, the state's Governmental Conduct Act applies to every person in government in the state of New Mexico. So the statutory Governmental Conduct Act is the body of ethics law that applies at the county level, at the municipal level. You're subject to it as officials and employees of the city of Albuquerque. The State Ethics Commission does not have jurisdiction in its administrative cases against locals, employees, or officials for violations of, for example, the Governmental Conduct Act, or those home rule municipality, or those non-home rule municipalities for the procurement code. The commission does, however, have the power to file civil actions against those individuals to enforce those statutes, but that only happens in very kind of serious and egregious cases. We do receive a lot of administrative complaints alleging violations of the Governmental Conduct Act from county and municipal officials against county and municipal officials. And those are routinely dismissed for lack of jurisdiction, but we see them again and again. and in part because just so many of the very small municipalities, I don't know if you've participated or observed, those council meetings at length, but oftentimes those people are at each other's throat. And that often results in us receiving ethics complaints from officials in very small communities around the state. And we don't have jurisdiction for them, but we review all of that. And if we see something particularly serious involving a county official or employee or municipal official and employee, we'll work it up and ask the commission for authority to follow a civil action to remedy and fix whatever's happened. And we've done that a few times.
Interesting, very interesting. I'm mindful that we have another important agenda item. Marissa Vargas is here. And is somebody with you, Marissa?
Yes, I have Miss Mesky along with me. She's the lead auditor for the department.
Thank you. So, Mr. Ferris, my sincere hope for me and for the board is that we have opportunities in the future to cross paths with you, because it's very clear that even though you've only been in there for 4 years, you're quite a subject matter expert, and we're delighted to have the opportunity to listen and have you share with us your perspective.
I appreciate that. I'm happy to meet with any of y'all at any time. We're close, so we're in Albuquerque. It's easier for us to do our jobs if we're not in Santa Fe. So we intentionally set up in Albuquerque. We rent space from UNM, so we're on South Campus in the Science and Technology Park. So we're just right up the hill. If any of y'all ever want to have a cup of coffee or come by and meet, please reach out. I'm easily found.
Awesome.
Okay. All right. Thank y'all. Have a good meeting.
Thank you. Mr. Roca, we're going to move to the final. You know what? My copy is too far away. Can you summarize the next agenda item?
Yeah, so next we have the city clerk selection update. I can just give a quick overview of the number of publicly and privately financed candidates, and then we'll move on to Marissa Vargas and Vanessa Mesky to give their presentation on the process and the findings of the Office of Internal Audit.
Nice. Is that good with you, Ms. Vargas, Ms. Mesky?
Yes.
Awesome. Thank you, Cristobal.
So fairly quickly, Chair and members, we had a number of candidates attempt public financing, about 11 total, and there were 13 candidates total that had to qualify or attempt to meet the threshold for 500 petition signatures to get on the ballot. So as of today, we sent the final numbers. Those candidates that met the threshold, there's about 8 candidates total based on an initial review of the numbers that have met the threshold for public financing. So about 8 candidates total out of the 11. Just to note, one of the candidates started out as a publicly financed candidate and withdrew before the deadline and became privately financed. Additionally, there's about 12 candidates, or there is 12 candidates that met the threshold for petitions, again, based off those initial numbers. So about overall, we have 12 candidates that will be on the ballot. 8 of them will be publicly financed, but this is just based off initial numbers. And so far, those are the candidates that have met the threshold.
Remind me what that threshold is, and then Jason Marks, please.
So it depends by district as far as qualifying contributions. Every candidate, though, does need to collect 500 petition signatures in every district. It depends on others' district numbers as far as voters, registered voters in each district. So, for example, District 2, they needed 381 qualifying contributions. In District 4, they needed 403 qualifying contributions. District 6, 333, and District 8 needed 446.
That's very interesting. Just thinking about Mr. Ferris, the mere fact that we've got that kind of a number in terms of the distribution of the contributions is certainly makes it more likely that no one person or a few have a headlock on the city councilor. If I can be so blunt. Did you have a question, Mr. Marks?
Yeah, could we just get the detail? Could Cristobal, could you go district by district and list the candidates that appear to have qualified and let us know which ones are qualified for public financing? I think it'd be helpful to know, just for background for our board, for which elections have public finance versus public finance, or private versus private, or mixed, just to get the context for what we might see the rest of the season.
Absolutely. Would you like just a general number for each district, or would you like the names of the candidates?
Yeah, let's have the names. I mean,
absolutely. So in District 2, we have Joaquin Baca. He's met the threshold for petition signatures as well as qualifying contributions. Next, we have Loretta Naranjo Lopez. She has also met the threshold for qualifying contributions and petition signatures. And then we have Moises Gonzalez, who has met the threshold for petition signatures, but has not met the threshold for qualifying contributions. In District 4, we have Councillor Brooke Bassan, who has met the threshold for petitions and qualifying contributions. The other candidate in District 4 is Abby Foster. She met the threshold for petition signatures, although she did not attempt for public financing, so she is a privately financed candidate. In District 6, we have Abel Otero, who has met the threshold for both the petition signatures and qualifying contributions. Additionally, we have Jeff Hohen, who is a privately financed candidate, although he did start off as publicly financed. He has met the threshold for petition signatures, as well as Kristen Green in District 6, met the threshold for both petition signatures and qualifying contributions. And Jonathan Alonso did not meet the threshold for either the petition signatures or the qualifying contributions. Nicole Rogers has met the threshold for both petitions and qualifying contributions. And in District 8, we have Daniel Champagne, who has met the threshold for both petitions and qualifying contributions. And similarly, Adelia Lechuga-Tena has also met the threshold for both. So those are all the candidates. You can also find this online. I'll put it in the minutes for the next meeting for you to review, but it's on our website as well, available for the public to see.
That's terrific. Yes. Any questions on what Mr. Roca just shared with us?
I just want to make one clarifying statement, and Mr. Rocha, correct me if I'm wrong. These are preliminary numbers waiting on finalization, correct?
Yeah, these are all based on initial review, and these are just the thresholds for the candidates that have met that.
All right, thank you.
Any other questions? Mr. Roca, will you, I'm going to ask Ms. Vargas to speak now, but in a sentence, summarize this agenda item, please.
Yeah, absolutely. So Marisa Vargas and Vanessa Miski have been great partners with our office in helping us finalize the process. This is a fairly new process that was passed last December. So we've quickly worked together and started this initial audit that their office has gone through. And all I would say is compliments to them. They're doing a lot of the footwork, and we're just reading the reports, but everything has been great to see their office.
Before Ms. Vargas, are you ready?
Yes, we're ready. And I'll turn it over to Ms. Meskey since she's the one leading this effort. But I just want to preface this by saying we are still in the middle of doing this work. So it's basically a summary of about 3 weeks worth of work that our office is doing to verify qualifying contributions.
That's great. And I will just ask Ms. Meskey, will you tell me what exactly is the Office of Internal Audit in connection with your presentation? Because I'm truthfully not familiar with it.
In connection with what, sir? I'm sorry, you skipped on that.
No, your Office of Internal Audit, is that a city level entity?
So, Ms. Vargas, oh, there you go. Okay.
Oh yeah, I can speak to that. That's fine. So we are part of the city, but we report to an independent body of citizens. So we report neither to administration or city council. Basically, we report to the constituents. So the work that we do is we identify risk within the city and then provide recommendations that hopefully mitigate those risks, making sure that departments are meeting their missions and objectives. And so in doing this effort, this work was sort of mandated in the updated ordinances that the city clerk recently updated in December. And since our office is independent, they turn to us to assist them in verifying some of the qualifying contributions candidates were receiving.
Terrific. Thank you.
Yes.
Ms. Meskey.
Yes, sir. If I may share my screen, we put together some quick visuals for you folks. Can I just get confirmation that everyone can see that?
Anybody
Yes.
who can't see it?
Okay, wonderful. So this is essentially a breakdown of our sampling approach of the initial 11 candidates that were seeking public financing. I'll just use the first line item as an example. That particular candidate running in District 2 needed to meet a threshold of 381. Our office will verify 5% of that, so 19, and then so on and so forth. And in total, we were committed to examine 206 qualifying contributions. So that's pretty high level. The next slide here is a really deep dive as far as how we planned on intending to meet those hard numbers. So again, we have the first line item, the counselor running in District 4. It'll show you how we intended to sample on a weekly basis. Our samples are indeed random. And what we do is we take those samples and we go out into the field, into the communities as a team of 2. And we go to the contributor's house and we ask them, hey, is this your signature? Did you indeed vouch for this said candidate? And did you provide $5 to their campaign? We tally up those results and we share them with the city clerk's office, which I'll gladly share with you guys as well. As Ms. Vargas said, we have completed 3 weeks.
Ms. Mesa, before you go,
go ahead.
What do people ask you when you come up to the door and say, hey, we're here to help you?
So we've seen a lot of individuals very pleased with the verification, just saying, oh, wow, I didn't know your office did that. And then we educate them again on the recent ordinance, letting them know this is a new engagement. We're moving on with it so far. We do have some contributors that are a little standoffish. We've received feedback as far as I don't understand why you're doing it. And again, we just do our utmost to educate as far as why. We just want to verify a random sample. So it's been pretty good.
That's great. I can see that it would be necessary from time to time to explain your role.
Absolutely, yes, especially since it's so brand new, right? And the fact that you have the candidates there 1 week and then our office is showing up the week after, which works in our favor because, they're getting their door knocked on 1 week and then we're showing up, hey, can we verify this? And like I said, the vast majority are pleased with that verification.
Nice.
Yeah. And then in our results, you could see the breakdown here, where in week 1, we sampled 57 qualifying contributions. We were able to verify 46. We didn't have any issues notated. In week 2, you'll see another 57 with 42 verified, and then 1 issue was identified where a contributor's house was vacant. I was there myself, and it was absolutely boarded up, and it had a vacant slip in the mailbox. So we indeed reported those results to the city clerk's office as well. And in week 3, we did another 49 with 44 verified. And that's where we stand now. We're currently in week 4, tallying up those results, and then we will commence week 5 tomorrow. We'll be out in the field again.
And how many more weeks do you anticipate it will take to complete your work?
So it's a total of 5 weeks, sir. So we are entering the last week. The qualifying period commenced on July 5th, and candidates were required to turn in their last booklets this past Monday. So we'll go ahead and select a sample of this last week, and we will get our final report to Mr. Watson to office next Friday.
And am I right? This is the first year you've done it, or am I missing that?
This is the first year that we've done an official, what we call a strategic review for our office for this work.
Mr. Chair, we, the Office of Internal Audit or whatever, did an, I don't want to say an ad hoc because that makes it sound like it was not well thought out, but they did a similar audit last year in the mayor's race and developed some of their methodology. I don't know if you developed your methodology then, but it was very, very useful and provided the board with, or 2 years ago, provided the board with quantitative and objective information about the qualifying contributions in the mayor race. So we've seen this before, but I think this is, sounds like this is the first year that it's done in a more pre-planned and global way, as opposed to responding to complaints.
And I'll confirm that. So it was the IG's office who led an investigation 2 years ago, and our office assisted, but definitely the approach is very similar, and we were able to take some lessons learned and some best practices from that effort and apply it to this approach. So it's been much more efficient this year, and hopefully whenever we have to do this again, it'll be even better.
And also the difference, I think, was doing a small sampling in the course of the qualifying contribution period instead of everything at the end, so that the candidates and this board can have updates throughout the process instead of just having to scramble at the last minute.
Correct.
Anyone else? Go ahead. I didn't mean to interrupt you, Ms. Meskey, Ms. Vargas.
Oh, no, I was completed, sir.
I
We're
think that's
definitely
it,
open for questions. Yes.
Great. Go ahead.
Mr. Chair, Ms. Meskey, the one aberration, the house that's vacant, well, actually more generally, in addition to trying to contact the contributors directly, do you review the documentation? Do you check if the signatures look approximately like the ones in the voter registration?
Absolutely. So the data is first fed through the city clerk's office, and they do the first initial review, and they're the ones that'll determine whether or not this qualifying contribution is accepted or rejected. Maybe Mr. Rocha could add more to that, but essentially once he approves all of them, puts them in an accepted state, we'll receive that. And then that's when we do our sampling methodology. That's when our sample selection. And then I will receive the original copies of the qualifying contribution form. And then I'm able to, yes, definitely verify the signatures.
Okay. So, I mean, in my experience, I've I've run for office. I've knocked on doors for other candidates. I've talked to voters and at places other than the houses, but it's not uncommon that people move and don't change their voter registration, and they know where they're registered to vote. And if you have a petition signature, if you're getting petitions, they'll give their old address. Is that what we think happened in this one incident?
In this particular incident, I'm not certain what happened. I would turn to Mr. Rocha for that guidance. Because when we selected it and it was in a accepted state, so I think he'll be able to add a little bit more to that.
Yes, so Member Marks, in my email last week, I also attached the letter that was sent to Mr. Baca, the candidate that this sampling was from. Yesterday, I received an email from Ms. Trailer, who was the resident of the address. And to my understanding, the front door to the house has changed from the side of 8th Street, which was where IA attempted to knock on the door. And she says that the entrance has actually changed to 9th Street, which is on the backside of the house. And so with that information, I'll check with the city clerk, but I think they've given us a prompt response and an attempt to rehabilitate. So later today, Vanessa and Marisa, you should get an email from me saying that that's been rehabilitated. But as of right now, we have not sent that official notice to the campaign, but just a quick briefing of the situation that's at hand.
So Mr. Rocha, you heard from the campaign, but you also heard from the contributor?
Absolutely, yes.
Okay, so then there's no question that the contributor actually contributed. The question was the address and the front door.
Exactly, and so IA has done a great job of taking pictures of the residence so that way we can see why it looks vacant. We also look at Google Maps. But yes, as of yesterday, our understanding is that it's the location of the door which has changed.
But that's, doors and addresses, that's some other city agency's department. Yeah. You at this point, you've been able to, through following it up, verify that the contribution was legitimate.
Yes, at this point, that's our understanding. And this is actually a good segue to the next portion that I wanted to present to the board, which is the rehabilitation process that the city clerk's office has set forth. So in our rules and regulations, section 2, part 11, we do have some examples to how to rehabilitate the qualifying contributions as well as petitions. There's no direct example for rehabilitating an IA finding, mostly because it's something fairly new. So what we do have is the word prompt. The candidates have to attempt to rehabilitate the qualifying contribution in a promptly following the notification from the city clerk's office of the rejection. So when we receive notice from the Office of Internal Audit, we notify the candidate by sending a letter identifying the contribution book, the page number, and the name of the voter that was identified as an error, or however the IA has determined that the person doesn't live there or there's been an error. From then, the letter includes information on how the process of the IA finds this issue, the name of the book, the qualifying contribution in question, and then we also provide notice that the qualifying contribution, the status will be changed from accepted to rejected, and then we also provide information on how to rehabilitate the error. So the letter says quite a few different things. Prompt is not defined in our rules and regulations, which we've decided that is something we'd like to address for next cycle. But in this time being, we just ask candidates to provide us a prompt notification that it's been rehabilitated in some way. Member Martinez?
Yes, thank you, Mr. Rocha. I know Mr. Baca had two incidents. So what about the first one that we received? Has that been
Mr. Martinez? Mr. Martinez, Mr. Rocha, before we answer that, I want you to answer that. I prefer that if you're going to use names, you use the name only of the candidate and not use the names of homeowners and contributors.
Thank you. So yes, Mr. Baca did have an initial on the first week. We also noticed, or IA noticed, that the house was boarded up and appeared to be vacant. That time, once we were notified, we sent a letter to Mr. Baca, and within a few days, we received not only a written statement, but also a property assessment with the written statement of the voter. And so at that point, the city clerk deemed it to be sufficient, and we rehabilitated that qualifying contribution. I believe IA was also able to go back out to the address and talk to the voter in question.
So just to follow up from the letter, it was a boarded up home. So it just, it's interesting that someone would live in a boarded up home. I mean, I guess it could happen, but.
I think Ms. Meske might be able to talk about how their office was able to determine that. But my understanding, what we heard from the voter, is that they actually live down a very long alleyway. And so you would have had to drive down that alleyway to actually see the front of the house. But I did go back out, and I'll turn it over to Ms. Meske.
Yes, that's definitely accurate. Our team went out there, and the first house that we saw, it was indeed boarded. And we did not go down the initial alleyway. We couldn't see that there was another home behind it. And so we thought that was the appropriate residence that we were seeking. And then, of course, later we were able to rectify, no, go down that alley. So again, we did go back. We were able to go down it and find the appropriate house. So it was essentially just this lot that had two properties, and we could only see the first one, which appeared vacant. And the second one, of course, was a valid contributor.
And sorry, thank you for that. Just another follow-up, Mr. Chair. But would we be able to, as a board, receive those notices when rectified? Just so we, I know we have this meeting and it was coming up, but if there's any other instances and we get a response from the candidate, can the board get those responses?
I think I'd like to discuss that with the city clerk. I'm not saying no, I'm not saying yes. But I'd like to make sure I understand everything that's at stake there.
John, this is Sean Kniff. Is this something that could come before the board in our adjudicatory capacity?
Good question, Sean.
Because my concern is that if we sort of talk about the details of an investigation and then the matter comes before us in our adjudicatory capacity, and we've had sort of previous knowledge about the investigation and talked to the investigators, if that could somehow impact our ability to adjudicate the issue. And maybe Adam knows the answer to that, but I just a warning.
I am working on looking for the answer to that, but initially off the cuff, and I apologize for just jumping in, Mr. Chair. That is correct. I would be concerned about the board receiving these documents at this early stage in the event that a complaint is filed and this goes to an adjudicatory hearing.
Awesome. That sounds like exactly the right approach. Do you agree, Mr. Kono? Sean?
Yes, sir, Mr. Chair. Thank you, Mr. Luschel. Is that right?
Luschel, but nobody gets it right the first time. It's totally fine.
Pardon me. But I mean, I think an abundance of caution is the right thing to do. We just want to make sure we keep our adjudications within the sort of four corners of the proceeding.
All right. Mr. Oka, am I correct that we have at least no other business on the agenda?
As long as there's no more discussion on the findings of IA or the rehabilitation process, I think the next item is other board business. And after that is
So to be clear, Ms. Maskey and Ms. Vargas, had you completed your presentation?
Yes, sir.
Okay. Is there any other board business that you'd like to address today? I'm underwater 8 minutes here. I've taken it to 10:08. So my preference would be to entertain a motion to adjourn, absent another important observation from anybody about substantive business. All right, is there a motion to adjourn?
So moved.